Well, maybe we will kick off now. Hi, everyone. Welcome to Spruson and Ferguson's third and final webinar in a three-part series titled IP Strategy Roadmap for the Food and Beverage Industry. We bring these to you in partnership with the Riddet Institute Centre of Research Excellence and with funding through the High Value Nutrition National Science Challenge. My name is Mike Zammit and I am a Principal and the Leader of the Chemical and Life Sciences team at Spruson and Ferguson, Australia. Our presenter today is Dr. Peter Brown, who is also a fellow principal in our team, specialising in the food and beverage sector. Peter has considerable experience working with his food and beverage clients to help develop IP strategies and progress commercially important patents both locally in New Zealand and Australia, as well as in target overseas markets. Prior to joining us, Peter worked in-house as an innovation manager and a patent attorney for a large multinational FMCG company, and also has been a co-founder of a startup food technology company. Today, Peter's webinar will focus on avoiding IP disasters, including cost blowouts, confidentiality breaches, IP ownership, and avoiding patent infringement. Of course, remember that nothing in this webinar should be taken as legal advice, and you should talk to an IP professional to work through your specific circumstances. As a firm, Spruson and Ferguson's patent attorneys have extensive experience filing and prosecuting food and beverage related patents, for example, in the fields of dairy, milk and milk solids, yeast, wheat and grains, fats, oils and lipids, natural and artificial sweeteners, proteins and amino acids, as well as manufacturing, storage and packaging technologies. In terms of logistics, today we are using Vimeo's webinar settings, meaning everyone in the audience is on mute with the video turned off and no one can turn either of those on. There's a live chat function at the bottom of the screen and you can use that to submit your questions to us during the webinar, and I'll raise as many of those as I can at the conclusion of today's webinar. We'll also follow up with individuals with answers to any questions we do not get answered today. Today's webinar is being recorded and we'll send all registrants a link to the recording over the coming days. With all that in mind, I'll now hand over to Peter to get the presentation underway. And I think today's presentation will take about 40 minutes. So thank you, Peter.
Thank you, Mike, and kia ora, everyone in New Zealand, and hello to everyone joining us from overseas as well. I do apologize if if the video is a little bit patchy. We have noticed there's a little bit of delay this morning, so I might turn my video off depending on how things go, but we'll just run with it and hope for the best. So yes, as the title on this slide shows, this is directed towards the New Zealand food and beverage industry, but obviously a lot of the opportunities and the insights are relevant to any company based overseas as well. So, as Mike said, this is the third webinar in the series. The first two webinars, if you weren't able to join us, was all about what is intellectual property and why is it so important. You know, some strategies around kickstarting your IP strategy and how to go about doing that at different stages of your journey. Explaining some different types of intellectual property for food and beverage companies and looking at the pros and cons of each of those and just weighing up what's relevant for your company depending on what stage you are in that journey. I gave some good examples of the flow diagrams of each type of the intellectual property right. So we looked at patents, trademarks, and design applications in particular. I've ran through a few case studies which hopefully were helpful. Looked at the different types of food and beverage patents, specifically in the industry. So there's a bunch that are looking at compositions, or it might be towards method of treatment or method of manufacture. There's the range of different things that can be patented in the food and beverage industry, despite a lot of people going, well, you can't patent stuff that are, just recipes. It's not about that. It's about, there's a lot of technology and new innovation that is definitely patentable and it is patented in the food and beverage space. And I think I alluded to Nestle's patent portfolio, which is astronomical, just to show that there is a huge amount of activity there. Ran through a handy decision tool, which will help you decide whether or not it's worthwhile going down that patenting route or not. And then in the other webinar, looked about how you can actually start to generate money from the IP rights and your patents in particular. So if you were unable to join, the webinars are actually available not only on our website. If you down at the bottom, you can see the reference to the website page. And if that's too difficult, you can also just jump on straight to the High Value Nutrition YouTube page, and the webinars are available there as well. So I will now carry on to what we're actually going to be covering today. So the focus of the third webinar is about, as Mike said, addressing IP disasters. And I often kind of make the metaphor allusion to what actually happens in a household. And perhaps I'm going through myself in our household. There's a lot of disputes going on. We've got two teenage girls and another girl that's about to become a teenager. So we get lots of these kind of disputes going on. Stop copying my idea, which kind of alludes to patent infringement. That's mine, give it back. That is almost a daily occurrence in our household. That kind of relates to the whole patent ownership dispute. I'm going to spill the beans. I'm going to tell on you, or I'm going to basically potential confidentiality breaches. That is very important when it comes to the patent side of things, as well as a number of other things, obviously even beyond intellectual property. And Dad, can I please have some more money? It normally starts with, Dad, I love you. Can I have some more money? So this is all about how to, look after your finances when it comes to intellectual property protection, as well as, trying to prevent those blowouts from happening in the first place. So I think when we look at all these different scenarios that can happen and are best to avoid, it's quite useful to actually look at the patent roadmap, which I ran through in the last webinar. It's just good to kind of refresh ourselves in terms of what's actually happening here. So as you can see, you start with the initial call, progress through to potential, searching to see whether or not this is something that is worthwhile patenting, and if you can patent it, or potentially there might be freedom to operate issues along the way before you actually decide to go down that route of patenting. That can then take, potentially up to 5 years, depending on which country you're looking at getting the patent protection in, and how long or short you want to kind of make that process. There's ways of speeding it up, or there's ways of slowing it down as well. And then along the way, there's obviously a number of decision points as to whether or not you decide to keep going with it or to let the patents lapse. And there could be opportunities throughout that where you're deciding on, is somebody potentially going to infringe our patent rights? Who are the potential collaborators that we might want to work with? Who could we potentially sell these patent rights to? All these types of things, attracting investment and so forth. So I think the general rule is, for any of the things that we're going to be discussing today, ideally you want to be talking about these things as close to the beginning as possible and considering the impact of those factors, particularly for confidentiality and ownership. These are the types of things you really want to sort out right up front. So understanding within your business what is meant to be kept confidential, who is potentially going to own the intellectual property rights. Is it a collaborator? Is it the inventors? Is it the company? All those types of questions. Even from an infringement point of view, and also I'll talk about this in a bit more detail, it's really important you start to think about these things as early on as possible, potentially even before you start the R&D process, because you can use that infringement analysis to help guide what you're going to be doing from an R&D and commercial perspective. And I think cost blowouts, when you're talking about cost blowouts, it's really important to think about that early on, but obviously as you're going through the journey and constantly checking back to see how it relates to your and business strategy. So stop copying my idea. I think this is the first one I want to talk about, which is, obviously in relation to patent infringement. The metaphor I've got here, a sister comes up with a cake design, in this case, Homer Simpson, only to get totally outdone by her smarty pants older sister that copies the idea, but of course claims that she didn't copy, with a very coy look on her face. And this does happen in our house on a regular occurrence. So the idea, when you kind of think about a patent, the idea is that it protects a concept, not necessarily how amazing the end product looks in market. And this is the beauty of patents, because you can potentially bring on partners or collaborators to help you commercialize your idea, even though you might not be the best one to actually make it look beautiful. And it, of course, helps stop competitors that, steals your idea, like the sister in this case, running with it and potentially doing a better job. So yeah, that's really great from your own point of view, but also from the flip side, you can also get into trouble if you're on the wrong side of patent infringement, and that's what we're going to be talking about. So unlike this situation where it's about this copying, when it comes to patent infringement, it doesn't really matter if you directly copied it, like copyright infringement. If you fall within the claimed scope of the patent claims, which I'll run through with you in a second, it doesn't really matter if you didn't know or not. You can still be held liable in most jurisdictions, and certainly can be stopped from continuing what you're doing. So just to give you an idea, when it comes to patent infringement, what is it all about? Essentially, it's when you make, sell, use, or import somebody's patented product or process in a specific country where the patent is held. So it's important to recognize that patents are territorial. Just because you found a patent that looks really gnarly in, say, New Zealand or Australia, doesn't necessarily mean you can't make or sell that product if you make and sell it in a different country where that patent is not there. The second thing to really point out is obviously the patent needs to be enforced in order for there to be an infringement. So if it's pending or if the patent is lapsed, obviously there's no infringement activity, but sometimes you can be held liable, obviously, for the costs or damages can actually date back to the date of publication, which could be actually before the patent is granted. So that's something to be aware of. The other key thing to bear in mind is, in order to actually infringe a patent, you must take each what they call essential integer or feature of a patent claim. And I've got an example here just to run through without trying to get too complex, and obviously a food example here. So this is actually a Perfect Day patent. They make the recombinant milk, alternative milk, and the patent claim here, even though it starts at this is a U.S. grant, it's in force, and it's due to expire roughly in 2037. So there's lots of life left in this patent, and if you were potentially going to be making something that's very similar to this could be a real concern. When you look at this patent claim, it starts at claim 101. In the US, they tend to delete claims and they don't renumber them, whereas in, say, New Zealand, you renumber claims. So in the US, this is actually the first independent claim set. So what you can see here is the claim relates to a composition comprising one or more recombinant proteins selected from the group comprising of. So that's kind of important terminology to get your head around in patent speak. That technically what that means is that to infringe that first integer of that, you only need to take one of those listed proteins. It could be more, but if you take at least one of those, it could be beta-lactoglobulin, or it could be a casey, for example. The second integer is wherein at least essentially one or more of the recombinant proteins comprises a sequence that is at least 70% identical to the bovine protein amino acid sequence. So that's the next integer. It has to be at least 70% identical to the equivalent bovine protein sequence. A trap for young players, perhaps, is that there's also a tagged on there and is produced in a fungal cell. So that's a separate integer. It has to also, in order to infringe, it has to also be produced in a fungal cell, which is interesting because that is technically a method step. And sometimes you can see composition claims that include a method step, which isn't the best drafting, I would say. The next integer is one or more sweetening agents. Then you've got also ash. And then interestingly, the next integer says, and optionally one or more lipids. So that is not an essential integer because it's an optional feature. So there's a few this is a good example of where you could get a little bit unstuck if you didn't know what you were talking about. And so it's really important, if you are really concerned about a patent, to speak to a patent attorney that will, he kind of lives and breathes this stuff and will be able to advise you relatively quickly the degree or risk of patent infringement, depending on what you're doing or plan to do. Another key point is that, this is one claim. This patent actually has claims 101 to 139. So there are things called dependent claims, which are dependent on, so in this case, it's claim 102 to 138 are dependent on claim 101. So these are essentially like narrowing down of that broadest claim 101. So you potentially could infringe this independent claim, but you could also infringe some of the dependent claims too. And then another trick as well is that hidden down right at the very bottom is another independent claim factor as well. So you might not infringe one independent claim, but if you infringe another independent claim, you still will infringe that patent. So there's some really important things to bear in mind there. Okay, well, now you've explained what it is. How can we avoid this from actually happening in the first place? So I guess the first point is, luckily in the food industry, patent litigation cases are actually relatively few and far between. But it does happen. And if you've been following the alternative meat companies in the US, you probably will see that the likes of Motif and Impossible Foods, they're big rivals, and they're at each other's throats in terms of patent infringement matters. Um, it's not a fun experience finding out that you're potentially at risk of patent infringement or being sent a cease and desist letter for a company. And it can seriously impact on your commercialization plans. And it's much better to front foot this and try and mitigate against this from happening in the first place. So here are some kind of quick tips in terms of how to avoid it. So the first thing, obviously, is to conduct a freedom to operate patent search as early on in the process as possible. And like I said previously, doing this even before you start your R&D project or getting kind of sign off internally is a good step to kind of go, here's the lay of the land. This is what we want to do and where we potentially want to do it. We've done a cursory freedom to operate review, and we have or have not found any patents of concern. And if you have found something that is of potential concern, that's when you can start to look at, well, is there a potential R&D workaround to avoid infringement? Sometimes it's a lot easier than others. Sometimes patent claims are very, very narrow, and you can still commercially play in that space, but avoid infringement. So it's much better to do that early on in the process, even before you develop your R&D. Getting down to the stage of commercialization, getting hit with a cease and desist letter, and then having to go back and rework the product, potentially change your marketing, all kinds of those things. Another key one, another thing that is an obvious thing to check is the patent about to expire? So, if the patent's about to expire in a year, maybe you can just time the commercialization and the R&D to align with when that patent does expire. Consider challenging the patent. So the patent system is set up such that obviously sometimes patents can get through where they are actually invalid, and there are grounds to challenge patents. And there's different ways of doing so. You can do through processes like re-examination, where you simply submit documents to the patent office, and the patent office will review those documents and consider from a novelty and inventive step point of view whether or not that patent is actually valid or not. You can take a more active approach where you challenge the patent, and you can provide evidence in terms of not only prior art documents, but it could be through an expert witness, for example, that is one of the leading experts in the world in that space that can talk about, for example, inventive step, or whether or not the invention is actually obvious or would be kind of obvious to somebody skilled in that space. The other thing that a lot of companies will consider is going down the route of, well, could we potentially license or buy this patent right off the holder? That could not only address potential freedom to operate issues, but it could also then lead to a situation where you've actually got the rights to the patent and can use that to your advantage as well. So that's worth considering. And doing some initial due diligence, you can actually find out relatively quickly if that company is actually commercializing it, and whether or not perhaps they're already licensing it to other companies. Maybe there's an opportunity there. And then finally, and I think something not to be overlooked, is that if you simply cannot get around a patent and there's just no way through it, sometimes the best thing to do is just simply, if you're early on in that project, so you haven't even started your R&D, is just simply kill the project and focus on something where it does have a clear path, and you've got the ability to commercialize without having these trip ups. I know it's not a nice feeling killing projects, but I've been in this space before, and sometimes the best decision is to kill things early. And actually, just to give you an example, we were recently involved in providing some advice to a client in the food and beverage space, where there was actually a question whether or not they would infringe a competitor's patent. At first glance, the claims did look somewhat relevant, but there was a lot of ambiguity because the claims weren't worded well. And so, after a thorough review of the patent and the description to understand the scope and the scope of the patents and what they actually were meant, it was decided that it was very unlikely that they would infringe, but it couldn't be completely ruled out. And so, what end up doing in this type of circumstances, you can also say, well, is this patent actually valid? And you can actually come up with some prior art and evidence that would support that even if they did enforce that patent on you, there's clearly no way that is valid, and you can counterclaim with a patent validity action or invalidity action. Obviously, on the flip side, patents can be useful for you to stop competitors in your space that you've got the ability to stop that from happening. And I've just been through a situation with another client where we've actually successfully gotten a competitor to stop commercializing a product that was infringing their rights. So moving on to the next one, patent ownership disputes. That's mine, give it back. This is a typical situation in our house, particularly with clothes, but I wanted to give you a food example here. So here's a burger that they're fighting over. So just like in a household, there can be real frustrations with everybody involved. In the startup environment, when it's comes down to who owns what, this can often be the demise of the company, just simply because there's a relationship breakdown because of this. It can also crop up when there's collaboration, multinational, when you're getting into some kind of joint venture, and obviously the relationships can break down there as well. So it can have a huge impact. And in fact, I don't know if I've run the stats or anybody has, but I think that a significant number of patent opposition cases or disputes arise through this ownership matter. So I'd say these are probably not all of them, but I would say they're probably the most likely types of ownership disputes that come up. So you've got the inventor disputes. This can arise when there's two or more people develop the same technology, or say it's in relation to food technology. And I think it's relevant because unless there's an actual assignment of rights, the legal owner of the patent is the inventor. So this is really important. And I think the other thing that it can crop up in for example, in a university environment where there might be incentives to be named as an inventor, there's obviously some good reason why people will want to be named as an inventor. I mean, they might get kickbacks or royalties or so forth. So it's an important thing to consider and not to overlook. Probably the main thing to identify is to maintain clear records of each contributor's involvement during the process. So when you're looking back and you're ready to file a patent application, you can look back and decide who actually contributed to that inventive concept and who didn't. The next one, again, very, very common, employee-employer disputes. This happens a lot of times, and actually was a case relatively recently that you may have heard about, UWA versus Gray, who was a professor at the university. So he was actually appointed. The actual story goes back to about 1985 when this happened at the university. In the course of the research, Professor Gray had developed a number of cancer treatments and ended up being patented. So he filed the patents in his own name and then licensed or assigned the rights to an external company, and obviously got paid a significant amount of money for it. Actually got shares in the company, I think, initially. So what actually happened was, looking back, and when this actually went to court, it was decided that Professor Gray's terms of employment through the university required him only to teach and to research, but it didn't extend to the requirement to invent. That wasn't in his contract. And more so, there was also a problem because normally there was a procedure in place at the university to report any new inventions that are intended to be patented through to this committee, but that committee had shut down years before, so it made it impossible for him to go through that process anyway. And so the court actually ruled that Professor Gray did actually own those patent rights and that the university had no claim to them. So I think it's really important in this situation, obviously speaking from the university's point of view, to have explicit clauses in the employment agreements. It's also very important to assign intellectual property, i.e. patent ownership rights early. That can actually be done as part of either in an employment agreement, or if it's for a specific project, say where you're working with an external collaborator and there's going to be inventors there, you can actually define that the project IP is going to be assigned either at payment for that project or automatically as even before the payment happens. So it's really important that you actually consider these and make sure that they're in signed agreements and that you keep a record of them as well. And I think finally, in this case that we were talking about just before with UWA, it's also really important to make sure your policies are kept up to date, even if you're a smaller company. If you're going to be developing intellectual property and intend to patent, make sure you keep your policies up to date so it can actually be followed by the staff. And the final example here, co-applicant disputes. Again, this is probably probably happens a bit less, but it does happen. And it typically arises when you get a collaboration between two different entities that are working together and they both see that there's an opportunity to utilize that intellectual property and want to be named as co-applicants on a patent. It's a great idea in theory, but in practice, it often ends up causing all kinds of problems. And my advice in general would be to avoid it if possible. If you do need to go down this track and that's really the only solution that's going to be amicable between the parties, at least make sure you've got obviously really clear written records of who owns what, and also the control of the intellectual property rights, who's going to pay for what, who's going to make the decisions during the patent prosecution, who's going to be who needs to sign off on potential licensing agreements external to those two companies, those types of things. There's tons of things that can arise during the patenting and commercialization process that you might not be aware of when you get into these agreements up front. So the next one we'll talk about is confidentiality, and I was trying to think of a good image to show you here, and I happened to be watching Young Sheldon the other day and saw the episode. I don't know if anyone else has seen this one, where Mima had managed to keep her beef brisket recipe quiet for many, many years, contrary to George's despair to replicate it throughout the night on the barbecue, and I think failed miserably. And it wasn't until young Sheldon, ended up spilling the beans to George and telling him the recipe after hearing Mima had told him the recipe when he was only 23 months old. And obviously, given that Sheldon is a genius, managed to remember this secret recipe when he was 23 months old, and repeated it to his father. So yes, confidentiality is super important. Secret recipes, especially if you're not going to be patenting something, keeping something as a trade secret is super critical, and you have to have ways of keeping that confidentiality in place. But I think if you are going to patent something, it's also important to have confidentiality, especially in the early time frame, because obviously, in order to get a valid patent, it needs to be novel. And novelty could be destroyed through, for example, scientific publication before you file a patent application. It could be through commercial use. And in the case of what Mima's done is technically what's called secret use. So if you're secretly using something commercially but haven't disclosed it, that can also be a grounds to challenge novelty, and you can see that in opposition or cases all the time. Excuse me. So Yeah, I think the key thing is to make sure that if you are going down that patent route, make sure that there are strong confidentiality clauses in place, and that confidentiality is maintained before filing the patent application. Um, it's also important not only just from a patent perspective and retaining trade secrets, but also I've actually got a story where I worked with a company in the past where the company, fairly large company, had a collaboration agreement with the university and had very strict confidentiality clauses in the agreement. Uh, but unfortunately, the university researcher um, failed to keep to the clause and decided on a whim to get an interview with a TV channel and disclose the research that was being undertaken. That was 3 years into a 4-year project, and a bunch of money had been sunk into it. But even worse, from a PR point of view, is that the researcher had decided to discuss a number of the company's brands in the interview, and make a number of comments that were potentially misleading or incorrect altogether. And this caused the company a headache in terms of trying to deal with the PR outfall or the fallout as a result of this. So it's really important not only from obviously keeping trade secrets, but it can seriously impact brand or your company's reputation. So it's really important to make sure that you're not only implement those agreements or collaboration agreements. You can also use non-disclosure agreements when you're working with external parties. You can, like I said, the next one down, any research agreement, make sure those are there, but also that they're being enforced. So um, I would strongly recommend, whenever the chance throughout a research project, to use, you know, catch ups. You might have a 6 monthly meeting with the researcher, maybe even monthly. Use it as an opportunity just to remind them of the importance of confidentiality, and even remind them about the contract itself. I found that to be very useful to help kind of just reinforce the importance of that kind of confidentiality in collaborations. And then I think the other thing, clearly identify all confidential material in your IP schedule, and we'll get to that shortly. And then also you can mark your products. For example, there might be reports that you're sending to collaborators, mark them as confidential, and you can even refer back to the confidential clause in your contract to reinforce that as well. So the last one we're going to focus on here is IP, and in particular patent cost blowouts. I'm kind of focusing on patents, as you probably can see throughout this presentation, but a lot of what I'm talking about can relate to other forms of intellectual property rights. So yeah, Dad, I love you, can I have some more money? So just as parents need to guide their children to make wise decisions with money and budgeting, businesses also need to take a proactive approach to runaway allowances in their IP protection efforts. So I would say that there's three main things, and this is the first one, and then the next slide will go through the next two. There's three main ways that I think that you can really help mitigate against these cost blowouts. The first one is doing upfront searching. So just to kind of introduce this, we've seen numerous companies and in the past where we've suggested that some upfront searching happens. They think that, oh, we'll skip that step, we'll go straight through to the patenting process. They file the patent, they've gone through the PCT, entered national phase, and then gotten examination reports in and identified a complete knockout piece of prior art that has means there's absolutely no way that patent is going to get through to grant. So that company has obviously spent a significant amount of time and money to get to that point. It could be 2 or 3 years to get there, and a significant amount depending on where they've filed their patents, which could have been avoided by doing that upfront searching. Let alone all the costs with R&D and commercialization, which are going to be significantly more than the patenting costs. So what I tend to do is I use a tool called PatSnap that I help my clients and do this kind of upfront searching and innovation analytics that helps kind of, as you can see here, a visual understanding of the technology space. Um, so it offers insights into where concept is positioned in the landscape. If you can see here, there's a small red triangle kind of sitting in the middle of that map, that landscape map. That is a concept that I plugged into the software, which is in relation to quercetin, if I pronounce that right, to prevent dyslipidemia and fatty liver disease. So it's an example of a method of use, so to speak, or a method of treatment using a food ingredient or bioactive. And so the idea is, okay, well, we've got this potential idea. We've got some preliminary data that suggests there's something here. We want to know whether or not, A, this is novel and inventive, or has it been patented before? Could there be potential infringement issues? Are there other patents around the space that are really high value that we could learn some useful stuff from early on? Are there potential licensing opportunities? Do we have to do the R&D, or could we simply partner up with a company that's already developed this and we can get some IP rights through that licensing arrangement? Or an example of this is, and I've actually indicated these, hopefully you can see them, little red dots. These patents, each dot in that map represents a patent. So you can see how the kind of landscape is spread out. You've got little red dots that represent all of Nestle's patents in that space. So you can see what's Nestle doing here. And then you can click on each one of these dots, obviously, and get details of the patent and read more about it. So this is a live software tool that I use. You can see all the blue dots there represent patents that are being under license at the moment. So you might be able to identify companies that are actively licensing their technology and would probably be open to discussing the same with you. The green dots that you can see a little dollar sign that represents patents that are of very high value. So you can learn some really interesting stuff there. And then from a novelty point of view, or even infringement point of view, you can actually zoom in on the map and click the area or the quadrant that's surrounding your concept that's positioned there using keywords, and then can zoom in and identify which of those patents potentially are relevant from a novelty or an infringement perspective. So that's one way of doing it. There's obviously others, but this is a really useful way of kind of getting a really good understanding, doing your due diligence upfront before you start a project. So in terms of cost saving, this is also really important because you can relatively quickly identify the potential novel and inventive features of your concept. And that can help you really narrow down and focus when you're drafting a patent specification on the features that are really novel and inventive. And make sure that you've got strong support for that. As I mentioned before, by doing this upfront searching, you can tailor your R&D and your commercial and product accordingly to avoid any significant roadblocks and avoid having to go back and change things later. And as I mentioned, by actually looking and searching at some of the other patents in the same space, you can see how other companies have developed their patent specification and the types of data that's been used to critically provide that support for a broad patent claim. So really, really important, and I strongly recommend this. The next one is having a property/commercialization strategy. This is super, super important. If you don't have clear directions of where you're trying to go, then it's very difficult to try and develop intellectual property costs within budget and making important decisions along the way. And I've seen this many times before, especially with larger companies. Sometimes, unfortunately, it's the case that obviously there's what happens is there's no commercial strategy in relation to some intellectual property rights. There's different parts of the business are working in silos, and sometimes you can get way down the track and there's still not a clear understanding of how you're actually going to utilize that intellectual property, how it's going to be commercialized, or what even it's trying to protect. It unfortunately does happen. So, and what happens then is they end up spending all these IP costs because you're unsure about where the project's going, where you might want to commercialize this product. And in a case that I've been involved with, even though I didn't advise it, the company decided to file patent applications at national phase in a huge number of countries because they just didn't know where they wanted to go. And that obviously leads to unnecessary costs. And sure enough, about a year later, they'd refined down their strategy and decided to abandon a number of those cases at ongoing costs. But if they'd actually brought that strategy piece forward, they would have avoided those initial costs up front. I think another reason why, if you've got a very focused intellectual property strategy and commercial strategy, that's obviously going to help attract investor funding. So if you're a startup looking for that initial money, that's obviously very important. Having a very clear IP strategy that you can get down on paper and put in your prospectus, that's obviously a really important thing to do. As I mentioned, it helps you deciding which actual countries you might want to file your patents into. And I think the other reason is that when you're actually sitting down with stakeholders in your business or collaborators, that you've got a clear, succinct document that you can run through to remind everybody what is the strategy with this intellectual property, and how is it going to get us to market, and how is it going to let us do well in market. So the third one is it's kind of linked to this, but having an IP schedule. So a lot of companies, especially perhaps smaller companies, might not have an IP schedule because they think, well, we know what it is, we don't need to write it down. But I think it's still important to get into the right habit and to develop an IP schedule. So typically what you want in an IP schedule, you want to have, in layman's terms, a summary of each intellectual property right and the business case for why you've actually got those intellectual property rights. How is it going to protect your product and market? And how are we going to use it? Another important thing, write down when the next deadline is. That helps to avoid urgency costs and making snap decisions too quickly. It also helps to avoid the actual IP right, for example, patent from falling over. If you're, for example, if you're managing it yourself, or even if you're working with a patent attorney and you don't send instructions through, sometimes what can happen is the patent can actually fall over because there's no instructions that come through. And then it can be a costly process to try and restore that patent or other IP right. So best to avoid it at all costs. In terms of, you also want to include in your IP schedule details around any co-ownership, collaboration, or licensing arrangement. Again, you don't want to get down the track of making decisions because you weren't aware that another party was involved. This typically happens in a larger entity. And then going, oh, whoops, sorry, we didn't check with you guys if this approach was correct. And now we've got to reverse everything we've just done and incur a bunch of costs. And another thing this is a good trick, is as part of your IP schedule, keep a really good record of any relevant prior art. This is actually important, obviously, for countries where you actually have to disclose through an IDS statement any prior art that you're aware of. But it's also really important and useful when you're going through the examination process. You can actually have a one-stop shop, so to speak, of all the relevant prior art you're aware of, anything that's been cited in previous exam reports, and the arguments that you've used successfully or unsuccessfully to overcome those prior art documents. Because as you probably are aware, often what happens is you'll get the same prior art documents being raised in different countries when you're going through the examination process. So having a really good understanding of the prior art, your patent attorney, to do that is a really good way of saving money. So I think that's actually all I wanted to go through. I just wanted to remind everybody that we actually have a really good page on our website. It's called the Technology Transfer IP Hub. It's free to access. You just need to log in. And it actually has a lot of this stuff in a lot more detail. So just as an example, it's got tips for conducting prior art searching, 10 things to consider after filing a provisional application and you're on the creation journey. So that's another document that's got a heap of really good ideas there about what to do to potentially prevent these unexpected costs from coming up. It's got a bunch of stuff on infringement in a lot more detail, and what is an FTO opinion and how do I go about doing it and what are the different types. There's a bunch of stuff around ownership, in particular around commercial agreements, licensing, and assignment considerations. And of course, a bunch of things around confidentiality. It's actually I think it's in that patenting basics document. So I strongly recommend, if you haven't already, to sign in and have a look around here. There's some really good stuff, as well as the webinars 1 and 2 are also on this page as well. With a bunch of other webinars on other topics. So I strongly recommend having a look there. And of course, feel free to reach out to me directly if you've got any burning questions of a confidential nature. Happy to talk through those with you. My details are on the screen here. So I will pass back to Mike now. Hopefully my internet didn't cut out too many times there and you were able to hear me. Cheers.
All right. Thanks, Peter, for a very interesting and excellent webinar. And I really enjoyed the "Dad, I love you, can I have some more money" analogies. Very good. I have a few questions for you. I might just ask you a couple. So the first one is, when exactly is the right time to do prior art searching to maximize the knowledge gained? Do you have a view on that, Pete?
Yeah, so as I mentioned, ideally you want to do it as early on as possible. There's obviously the limitation that sometimes if you're at the very early discovery stage in your R&D project and you're just trying to figure out where you might want to go, it's worthwhile doing some kind of search at that point just to get a lay of the land, like I said, and potential things that you want to avoid. But obviously, as you go through and refine your scope of product or whatever you're going to be developing, and then you actually go through and conduct R&D on that, you might find that it's actually taken a slightly different path than expected. And there's obviously merit in doing some further searching at that point, because there might be some unexpected results that support patenting. And you've gone down a specific thing that's made it much better than you initially intended for. So there's obviously the benefit of doing a top-up search or a specific search on your revised product at that point, or method, whatever it is. But yeah, definitely my advice would be to try and get in and do some searching early on. It doesn't even necessarily need to be through a patent attorney firm. Obviously, we'd love to help out, but early on when you're doing that searching, you can even just do it through Google. But tools like I've used, PatSnap, it gives you a lot more richer insight into a bunch of things, including licensing opportunities, who your target company might be, and tailoring it to target them.
Great. Thanks for that, Peter. And I will just ask you one further question. Given you said that patent litigation is uncommon in the food and beverage sector, then why bother getting a patent in the first place?
I think I got it. So I think the question was, given I said it's relatively uncommon that you actually see these patent infringement cases, why bother going ahead with a patent? I think that was it. But so yes, I think, as I mentioned, I think it was in the previous webinar, the key thing about getting a patent, especially in the food and beverage sector, is that yes, it's very uncommon that you actually go through that litigation case, and ideally you want to avoid that at all costs because it's expensive. But the patent is actually a proactive tool that you can use in business. So I think I mentioned in the previous webinar, you can use that for gaining kind of confidence when you're speaking to investors to get early stage seed funding and going through that different process. You can gain attraction from collaborators and define what intellectual property you're bringing to the table. You can use it for advertising purposes around marking your products with patent pending, or in your promotional material. So it kind of helps you look as if you're an innovative company, which you are. It can be used obviously for your exit strategy, so it helps build up the overall value of a business. So when you're ready to go and sell, you can actually then offer that as an intangible asset that you're offering alongside other valuable parts of your business. For example, trade. And obviously linked to that as well as having a patent, even though you might not be enforcing it, it can be used as a tool for licensing deals that can be built into the actual licensing agreement and so forth.
Great, thanks for that, Peter. So I think that concludes our presentation today, and I'd like to thank everyone for attending. If you have any questions or want any further information, please reach out to Peter directly. His contact details are on the slide currently on screen. So thank you for your attendance today.